individual citizen could bear either in personal activities or as a member of a militia. And Heller provides tools like courts do when they're actually trying to make constitutional law work rather than try to come up with any corner from which to get this thing out of the room. Heller said, we'll use a common use test, and judges don't have to make personal judgments about which weapons are appropriate. We'll look at the practice of the law-abiding public, which is what Heller did. He said handguns are clearly in common use and preferred for legitimate purposes by Americans today. That's been true for a long time. They're a protected category of arm. There's nothing untoward about this unless you think, and this is a point that I want to make, that the tools of constitutional lawmaking, the enterprises of constitutional deliberation and recognition should not be available to the cultural right under any circumstances, only the cultural left. This is a post-Obergefell world, and it's not available to the left to argue that things that are fairly debatable and there's empirical issues on both sides, especially if you can't ground them in history, should not be constitutionalized. The Supreme Court has done that with the abortion and gay marriage cases, and conservatives are just as entitled to use that example as any other. And if you want to get rid of the one, you have to sacrifice the other. If you want to talk about the political process, well, actually, I wanted to say about Republican appointees, what my article actually found is that, with exceptions, by and large, and it's gotten better recently, judges appointed by Republican presidents routinely rejected weak Second Amendment claims. You know, I have a right to a hand grenade, or I have, been convicted of violent bank robbery 3 times, but I have a right to keep and bear arms. And then debatable questions: can you prohibit carry outside the home unless you get a May issue permit? Can you ban 7-round magazines, magazines above 7 rounds? Those judges sometimes upheld and sometimes struck down. It was the Democratic appointed judges that had a staggering uniform record across a couple of hundred cases over more than 5 years of rejecting every single claim on the merits for Second Amendment relief. Half of the legal culture is treating this like law, trying to make it work, and reaching results that are perfectly in tune with the sorts of things that Second Amendment scholars have been arguing it for a long time. It's the other part of the legal culture that needs some reform. One last point about law school classrooms. If you know the facts of the horrible Virginia Tech mass murders, which were committed by, that piece of trash was a perfectly nondescript individual with a common handgun, any concealed carry permit holder who was halfway competent would have had a good chance against that guy. The Umpqua Community College shooting. Police, if they're doing a good job, could get here in just a few minutes. Just a few minutes. The idea of allowing people to carry in more public places is basically distributing self-defense, crowdsourcing it, if you like. And it is precisely mass shootings where you can have so much havoc wreaked so quickly that that sort of distributed defense makes the most sense. And finally, I gotta say, the whole locution, the gun lobby is funding pro-gun rights reforms is extremely strained in the age of Michael Bloomberg.
I think we'll move to student Q&A. We got time for a few of them. So, who has a question for either professor? Jacob, right over. Professor O'Shea.
Yeah.
So you mentioned the common use test in Heller as a way of preventing anti-aircraft guns being something that the average citizen could own. But could you explain from like a political perspective why we should read that limitation into the language of the Second Amendment?
Well, it's an interesting question. If you take individual self-defense as your guiding thread in the Second Amendment, that approach makes sense. And it wasn't ginned up by the Heller majority. You can find cases going back to the early 20th and even the 19th century that take basically that approach, that you look at not civic purposes like military readiness or deterring tyranny, but personal purposes like personal defense and hunting, and look at what people choose. And, you know, Thompson submachine guns did not sell well during the brief period when they were available for private purpose. That was not what most people wanted. Handguns did, shotguns did. You know, today, non-lethal weapons. In several state courts, the U.S. Supreme Court decided a case, sent a case back to the Massachusetts Supreme Court on the view that it had used wrong reasoning to exclude non-lethal stun guns from Second Amendment protection. So if you take that as your thread, and that is consistent with the development of state constitutions, it's consistent with what probably most people value their right to arms for today. These are very mainstream constitutional considerations. Then you get something like Heller's common use test. Part of it was, you know, quite frankly, they didn't want to give anybody the idea that there was a right to own machine guns. And, you know, that just is what it is. I sort of look at it as there are obscenity laws, they're traditional, and even if there's some stuff covered by them that you might think has some expressive value, they're considered carved out of the right to arms. And so, you know, weapons that have an exclusively military use and don't come into common use for the citizenry fail the common use test. I will say, I've argued in print that if you, the worry some people have about the common use test in the pretty rule-like objective form that I'm proposing it is it might be under-inclusive. You know, what if there are weapons that would be appropriate for the people to keep, but they get banned so quickly that there's no chance to get them into common use? And I propose a police corrective for that. Not, you know, SWAT teams or something like that. You can kind of view those as the equivalent of what the founders would call the select militia. But an ordinary beat patrol officer is something a lot closer to an ordinary militiaman. And if there's some kind of equipment that is routinely issued to ordinary police in a jurisdiction, that should at least be a factor. That's prima facie evidence that it should be treated as a protected arm under the common use test. This is, you know, this is some common law kind of, you know, making trade-offs sort of doctrinal formation, but so is every other topic you're going to study in con law. And that's the theme I want to sound here. The idea is, you know, a right that is actually valued by the cultural right has to be minimized and not allowed to do the sorts of ordinary things that courts do when they're giving flesh to a constitutional right.
We got time for one more question. Be bold, one else there. All right, Professor Young. We'll go.
No students can ask. I have a question. I guess in Scalia's argument, the right to self-defense and right to bear arms are coextensive in the home, and I can see that and you know, think it's a square argument. But outside the home, it strikes me that they're often in conflict. And using stories like Tamir Rice being shot within 2 seconds of police arriving at the scene when he had, you know, just a plastic gun. You know, we give lawful or lawful support for both police and citizens to treat guns as threats. And another example in the contrary direction, Mika Johnson shot and killed 5 Dallas police officers believing he was overthrowing government tyranny. And so in public, you know, because of the fact that 2 people can exercise their right to self-defense in a way that both of them are justified, does Heller actually require us to limit the right to self-defense or limit substantive criminal law self-defense to make it so people can't carry? Or is this just inevitable in a Heller world?
The Dallas shooting example isn't apposite to a discussion of routine carry for self-defense because that was somebody who lay in ambush with a rifle. The Tamir Rice example, I don't have much to say about that other than that seemed like negligently bad police tactics to respond to a brandishing call. Having said that, and I would have, you know, if I were the DA, I would at least have investigated it with that frame of mind, knowing the facts. Having said that, brandishing laws themselves are workable, and there is a tendency, you know, I myself think, you know, I've argued that I think concealed carry is the best solution, and then you're not going to have, you know, man with the gun calls, so that's one thing. Brandishing means taking it out, and that is illegal under the laws of all states, and it is not the same thing as open carry laws. You're not authorized to brandish a gun even if you're in an open carry state like Kansas. You have to have a threat. So I think that's there's nothing about the distinction between carrying and brandishing that raises any trouble for the constitutional right to carry. And I just think the Tamir Rice case is just an example of clearly bad and I'm plausibly negligently bad police tactics for responding to a brandishing call.
All right, well, thank you all for coming out. It's been a fantastic discussion.